Yes, welcome to the No Stay Project, and yes, we have two more success stories to post here at markstevens.net under the success stories here. Yeah, they're getting pretty, it's getting pretty filled up here. We've actually had four that I wanted to report, but I don't have the documentation yet for two of them, so we're just going to be reporting on the two. So you'll notice as you go down, if you are looking to learn how to effectively defend yourself against tickets or let's say drug charges or tax charges. If you go through this, you'll notice that we've been able to replicate the success that I've had on three continents, including Israel. These are just some of the success stories that we have, and we always wait until we have the documentation to be able to post it up there. So when you go through all of these, you'll have the documentation that goes with it to show that it was thrown out. And these two are no different. In fact, the first one is a little different because it's from federal court, and we generally don't have much success at all in federal court. But this we did. This is actually a disorderly conduct, which is usually, admittedly, contempt of cop. You just you just bruised the cop's ego. I don't actually know the details of that, though. I do know that Jordan did file the motion to dismiss and discover request against this trash. And this is in the Central District of California, Southern Division there, the United States District Court. And after filing the motion to dismiss and the discovery request, and remember, the discovery request is looking for Brady material. We want to know the evidence, any exculpatory evidence or information, any information that is material to show innocence and is impeachment material against the witness. And of course, the witnesses have to have personal first-hand knowledge of the matters they're testifying to. And if they're testifying that Jordan was subject to the laws of the United States because he was in California and that he violated them, they have to have personal knowledge of that. So after filing the motion to dismiss, which is, of course, based on a lack of evidence proving jurisdiction, which is based on the prosecution's claim. Yes, I know it's the same thing, but they are claiming this Denise Willett or Benjamin Lichtman. They are alleging that since he's in California, the Constitution applies, and that gives the court territorial and personam jurisdiction as well as subject matter jurisdiction. They have to have personal knowledge. The witnesses have to have personal knowledge of the evidence the prosecution is using, and of course that doesn't exist. They can't get standing to complain because there's no evidence to support their claim that the Constitution and Code apply. Now, which was nice that the attorney filed an ex parte motion to dismiss the pending citation. Ex parte meaning they did it without notifying Jordan first, which usually is, it's not a big deal. Usually it's a big deal, but here we didn't give a damn. We jumped ahead. So what we have here is the proposed order, which was then crossed off by a court staff or the judge, where he says, based upon the government's application to dismiss the citation, which charged a violation, and the violation is right here, it is making statements or other actions directed towards inciting or producing imminent lawless action and likely to incite or produce such action. That's the disorderly conduct at the federal level there. Which is that's what he's being accused of there. In good cause appearing thereon, it is hereby ordered that the government's application to dismiss the citation without prejudice is granted. I wish it was with prejudice, but hey, we'll take it. Is granted pursuant to the Federal Rules of Criminal Procedure 48A. So I think we go back here. This is the second page where this is the defendant's copy, so that's why there's not a signature on there. But that is the magistrate that granted the order to dismiss. So big congratulations to Jordan, and thank you so much for sending it out to me. We have another one that's a little not as common as we're usually getting here at the No Stay Project, but it is a credit card one, and we haven't had I don't remember a credit card dismissal. We haven't had one for a while. The last one you can look up. You can go into you do a search at markstevens.net, and you can see that it was a big deal with our friend Armando in Southern Texas. But this one is coming out of Cleveland, Ohio. or Ohio. And it is credit card. And Jerry sent this to me. I don't know Dwight. I didn't work directly with Dwight, but Jerry was helping Dwight with this. And also here, and this is a civil proceeding, the motion to dismiss is a little different. Basically, it's pretty much the same thing. It's based on a lack of evidence proving jurisdiction and that there's a valid cause of action. And he filed a motion to dismiss with a discovery request without the Brady material. Well, we just don't call it Brady because the bank here, or Midland Funding, their attorney is still responsible to have competent witnesses to testify to the matters that they have to have personal first-hand knowledge of the matters they're testifying to, and obviously they're testifying to a violation of Ohio law. So after filing a motion to dismiss and a discovery request, and a little bit of detail that I do have here, that Dwight did go into court, did stand on the motion, insisted that the prosecution, that the prosecution had to provide the discovery, and the judge actually ordered them to do that. And instead of providing the discovery, basically supporting their claim and their complaint, they filed for a voluntary dismissal. Notice, a voluntary dismissal without prejudice. Yes, I would like it to be with prejudice, like with Armando, but hey, we'll see what happens here. A dismissal is a dismissal. Now comes the plaintiff, by and through counsel, does hereby dismiss defendant Dwight within action without prejudice pursuant to Civil Rule 41A1 at its cost, notice by the clerk being waived. That voluntary dismissal, we have that here for Ohio. We don't have an order from the court at this particular point. It's kind of seems clear that we don't need to do it by order of the court. It's a voluntary dismissal. By plaintiff, subject to the provisions, plaintiff without order of court may dismiss all claims asserted by that plaintiff against the defendant by doing either of the following: filing a notice of dismissal at any time before the commencement of trial, unless a counterclaim which cannot remain. There is no counterclaim. There was a motion to dismiss that was pending that they could not overcome. So big congratulations to Dwight, and appreciate Jerry for sending me the documentation here that we can we'll have posted at markstevens.net. I do want to point out real quick. Again, this is Iqbal, Ashcroft versus Iqbal, and there's the citation there. It is the United States Supreme Court. And what they're saying here is they're just restating what and I've been repeating this for years. Detailed. All right, we're talking about the rules for a sufficient complaint, and and Rule 8 is mimicked by Rule 8 in Ohio. Detailed factual allegations are not required, but the rule does call for sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. A claim has facial plausibility when the pleaded factual content allows a court to draw the reasonable inference that the defendant is liable for the misconduct alleged. What's important here is typically what lawyers will do, especially those who are U.S. attorneys or state prosecutors, will only put in legal conclusions regarding issues of jurisdiction and the violation of the law, or if the law applies in the first place. They'll just have legal conclusions. So it's important here. Never lose sight of this fact. A court considering a motion to dismiss may begin by identifying allegations that, because they are mere allegations, are not entitled to the assumption of truth. So whether someone's a citizen, whether someone is a resident, that is an assumption. That is a legal conclusion. That is not a statement of fact, no matter how much they want to tell you otherwise. It is not a statement of fact. It is an allegation. It is a legal allegation. It's a claim, a legal opinion. So this is where if this was, if they actually applied this to the U.S. attorney, they would be a hell of a lot less successful against us. While legal conclusions can provide the complaint's framework, right, they must be supported by factual allegations. Okay? Very, very important. I've said that, I'll keep saying this because it is so damn important. While legal conclusions can provide the complaint's framework, they must be supported by factual allegations. So when the IRS says that you're a citizen, where are the factual allegations to prove that? None. When they say that you are subject to the law, that is a legal conclusion that must be supported by factual allegations, and they have nothing. They don't think they have to prove that. They'll actually sometimes argue, trying to make you believe it's a trial issue only. No, this is a rule of this is the rule for a complaint itself. What gets the whole thing started? It is not just a trial issue. They have to be in the complaint. It's prima facie at that point. They don't have to prove it beyond a reasonable doubt, but they have to be in the complaint. This is the United States Supreme Court. This is not me saying it. While legal conclusions can provide the complaint's framework, they must be supported by factual allegations. And that's why these complaints fall flat on their face, because they don't contain factual allegations, especially, like I said, when we're talking about something from the U.S. Attorney's Office, because they don't. They just make the assumption that the laws apply, but they don't have any factual allegations to support it, and that's why I believe a lot of times they have these things that they get tossed out. So big congratulations to Dwight and Jordan for getting those kicked out, standing up to these predators and not listening to the nonsense that you can't defend yourself, and that you absolutely, if you are going to defend yourself, you need an attorney. The success stories here at markstevens.net would say otherwise, and we'll get these two most recent success stories posted, so we have the evidence of more success here on markstevens.net. If you disagree with what I presented here, hey, more than welcome to call into a live broadcast of the Big Show. We are live 4 hours a week on Wednesday and Saturday, so feel free to and welcome to call into a live broadcast and set me straight. Again, my name is Marc Stevens. This is another edition of the No Stay Project. The website, of course, markstevens.net.